Supreme Court of India, 5-judge bench headed by the CJI in response to the opinion sought by the President under Article 143, conducted hearings and gave its opinion today. The opinion is not binding, it's an opinion, it's a view. It has been consulted and this is the opinion of the Supreme Court delivered. It's about the earlier verdict of the 2 judges of the Supreme Court, the division bench, on the 8th of April about the powers of the governor, powers of the president in relation to the state bills passed and sent to them. Then the Supreme Court gave a unconventional verdict, went far beyond its constitutionally assigned powers, available powers, and then said that the governor doesn't have pocket veto, governor doesn't have absolute veto, timelines are laid down under various circumstances, and in case the timelines are not stuck to, at the end of the given time, the bill is deemed assented. The doctrine of deemed assent under 142. Similar is the case with the bills under 201 kept for the president by the governor, wherein the timelines are laid down and also a dumb part of the verdict was clearly visible. That every time such a bill is kept for presidential consideration, the president is to refer the same to the Supreme Court for its opinion under Article 143. That's a clear case of non-application of mind on the part of the apex court. So, in this verdict of the Supreme Court, it created a doctrine of deemed assent, it laid down timelines, and it even opined on the bills which are pending, that is, they are pending on the table of the governor or the president. And the question asked of the Supreme Court was, can a pending bill be referred to the Supreme Court for its adjudication? But that's a clever question, not an intelligent question, not a constitutionally moral question, because no one is questioning the contents of the bill. They're questioning the inaction, gubernatorial or presidential, and that must be differentiated. Now, what does the opinion of the Supreme Court today, though non-binding because it is 143, not 141, so what does it say? It says the regular generalities about separation of powers, parliamentary democracy, federalism, and so on and so forth, but it has almost nullified the entirety, the actionable part of the April 8th verdict. It said no timelines can be laid down. It said that the governor is not a rubber stamp and has some discretionary power. It said the presidential satisfaction is not to be questioned by the judiciary. It set aside the doctrine of deemed assent as alien to the Constitution. So when the verdict threw the Constitution out of the window while upholding constitutional morality, everyone loved it, but it was unconstitutional because 2 judges of the Supreme Court cannot do what 5 judges should do under Article 145 for a matter concerned with the constitutional interpretation. This opinion of the Supreme Court, on the contrary, it does the reverse. That is, it respects the Constitution as minutely as possible, but disregards the constitutional morality completely. Therefore, this opinion of the Supreme Court is quite opposite to what was delivered on the 8th of April by the 2 judges, the division bench. Now, the Supreme Court today said clearly that we are not recalling, we are not reviewing, we are not junking the April 8th verdict. We are just giving a view, and this view is non-binding. It's only an opinion. We've been consulted and we have given our advice. So now what happens to the April 8th verdict? Is it operational? Are the governors and the president bound by it? Or is there any other technical course of correction that is available? We don't know. But last time, the 2G verdict, if you recall 15 years back, that held even after the Supreme Court gave its opinion under Article 143. So there you have April 8 compared to November 20. The Supreme Court's verdict versus the Supreme Court's opinion. What is to be operational between the two? The former is operational. The latter is only an opinion. But it will be important that the Supreme Court clarifies as to the status of the April verdict regarding the gubernatorial and the presidential powers.